All right, welcome back. I'm not sure if we have new groups of students in the audience, so I will just kind of briefly go over how we handle things. Each side has 20 minutes for argument, and if the appellant wants rebuttal time, please let us know on the front end. We've got the timer to take care of that. Anything else we need to address?
No, Your Honor.
All right, if you'll call the next case, please.
State of Tennessee versus Clarence M. Porter.
Good morning, Your Honors. May it please the Court, Brennan Wingirter on behalf of the appellant, Mr. Clarence Porter. With the Court's permission, I'd reserve 4 minutes for rebuttal. Your Honors, we've all heard the phrases, wrong place, wrong time, guilty by association, you are the company you keep. Those phrases are not the law in Tennessee. In fact, Tennessee law is quite the opposite. A person's guilt in a criminal case cannot be based on their mere presence at the scene of a crime. A person's guilt cannot be based on their mere association with other people who commit crimes. And, at least now, in this case, it is still the law that a person's guilt cannot be based on the uncorroborated testimony of a charged co-defendant or accomplice. But those 3 things, presence, association, and uncorroborated accomplice testimony, are all that the state has against Mr. Clarence Porter in this case. Without any corroborating evidence of the accomplice's testimony, and without any independent evidence establishing Mr. Porter's commission or intent to commit any of the charged crimes, the theft, the robbery, or the ultimate murder in this case, means that Mr. Porter is serving a lifetime in prison for crimes that he did not commit. Now, we know that Mr. Blake Orr is the person who pulled the trigger and shot and killed Mr. James Johnson. We know that Mr. Orr was there that day because he got a phone call from a woman named Queena Brown. Ms. Brown and Mr. Orr both pleaded guilty to their roles in the commission of these crimes, and they are serving time in prison. Mr. Porter, however, was there, literally along for the ride. And I think what is probably the best, I'm happy to answer any questions that the court has about any of the issues raised in our briefs, but I would like today to focus on that accomplice corroboration rule and the lack of sufficient evidence of Mr. Porter's intent or participation in any of the charged offenses. Of course, I'm also happy to talk about the conspiracy and hearsay issue and the prosecutorial misconduct, if the court would like. And I would, just for the benefit of the audience, I would note that Ms. Redding, who's here on behalf of the state, was not the prosecutor at trial and did not write the brief for this appeal. And so anything I say about the state either misrepresenting or misconstruing the record is certainly not personal.
So, counsel, before you start, let me make sure that I understand where the argument is going today. Would you concede that if Ms. Brown's testimony were corroborated, that there's sufficient evidence then of intent against Mr. Porter?
No, Your Honor.
Okay. So her testimony alone is not sufficient to sustain the conviction if it were corroborated?
Correct.
All right. How is that? Can you help me, please?
Yes. So I think it's important to remember the way that the legal standard works in this case. So to start first with the corroboration rule, the trial court had to rule, and did rule, at the mid-trial motion for judgment of acquittal, whether there was sufficient corroboration of Ms. Brown's testimony for the crimes to even go to the jury for consideration. So at that point, it's sort of a preliminary quasi-legal, quasi-factual determination by the trial court about whether there was sufficient corroboration. It then went to the jury. So the corroboration does not have to prove, or the corroborative evidence does not have to independently establish guilt beyond a reasonable doubt.
Sure, and it only has to be slight for those purposes, but taking that aside, let's assume that it's corroborated, let's assume it's credited by the jury, and if we view her testimony in the light most favorable to the state to sustain the conviction, as we would have to as the law requires us in this court, her testimony alone, you're saying, would not be enough to support a finding of each element beyond a reasonable doubt?
That's correct.
Which elements would be missing?
So if I may take one liberty to first correct just one thing about the legal standard. Your Honor said, however slight. And I do think that the corroboration rule for accomplice corroboration is higher than that.
I want to get to corroboration. I'm just saying, let's take that off the table right now just so I know where the argument is headed.
Yes, Your Honor.
Let's assume it's corroborated. I know we'll talk about that in
Okay.
a minute. Assume it's corroborated, assume it's fully credited by the jury, and we have to give that deference. Which elements does her testimony not satisfy?
Okay, so the crimes were theft, robbery, and ultimately a murder. Because it is undisputed that Mr. Porter did not actually commit any of those, the state's theory was based on criminal responsibility. So for criminal responsibility theory in this case, for the theft, the state had to prove that Mr. Porter had the shared intent with Mr. Orr and Ms. Brown to take something from Mr. Johnson. That's number one for the underlying predicate offenses. The state has to first prove
Or
those.
to benefit from somebody else's robbery?
Correct, Your Honor,
Okay,
yes. So if those are proven, then to get to the felony murder, the state still has to prove that the killing, the death, was connected to the predicate charged offenses. So we really have two prongs of attack against the state's case there. Number one, even if you accredit Ms. Brown's testimony, and even if there's sufficient corroboration, there's no proof that Mr. Porter intended to participate in these crimes. So for the theft, for example, the underlying predicate, I'll talk about the theft and the robbery kind of together because it's both about a taking. The state's only evidence, other than Ms. Brown's testimony, and even if you take Ms. Brown's testimony, the only evidence against Mr. Porter was he was there. Initially, Ms. Brown said Mr. Porter never got out of the car. She later changes her story and says, I don't know when he was in the house, but at some point he was in the house with his hands in his pockets. He didn't touch anything. He didn't take anything.
Didn't he supply, though, the weapon that Mr. Orr used?
Your Honor,
according to her?
That was not, according to her testimony, after they returned back to Chattanooga, Mr. Orr handed the firearm to Mr. Porter and said, essentially, here you go, get rid of this. That, however, was not proven beyond a reasonable doubt, number one. It wasn't even established by anything other than her saying that that happened.
Okay, so if we fully accredit her testimony that that happened, that would support, would it not, the aggravated robbery, right? Because he's providing the weapon that's used in the theft.
So, but I don't think that we can do that, Your Honor, because even if you accredit her testimony, she's still an accomplice. So you don't get past the corroboration.
Okay, all right. We keep going back and around. I think my questions right now are assuming that it is corroborated. I know we're talking about that, and the court's certainly not there yet. I'm just trying to figure out, on her testimony alone, if we credit everything, I think we would have to credit that Mr. Porter gave the weapon initially to Mr. Orr that was used in the homicide, right?
I don't think the court has to conclude that. Number one, the trial court didn't conclude that.
Okay.
Number two, that never went to the jury to decide.
Okay.
So this court would be making a factual finding that was never made at the trial court level if the court decided to do that.
Okay.
And I don't think this court can do that. Another point to that is, again, the firearm was never recovered. And there's nothing other than Ms. Brown saying, Orr handed it to Porter, Porter took it inside and got rid of it. That's it. That's not enough to prove that, one, he provided it, and two, that he knew from the outset of this round trip that he went on with his friend that any of this was going to happen. And I think that's actually bolstered by Ms. Brown's testimony, if we are going to credit everything she said. At one point, she
And
testified.
we have to, right, if it's corroborated?
If it is corroborated,
Okay,
Your
sure.
Honor. And at one point, she said that Mr. Orr, right before he shot Mr. Johnson, said, if you ever touch her again, I'll kill you. That is wholly unrelated to the state's theory of this was some attempted theft, robbery, they were there to take collateral. If you really look at the context of this case, Mr. Orr has some sort of, I don't know if it's like a hero complex or something, where he is there thinking he's trying to avenge Miss Brown, who was living with Mr. Johnson at the time. That had nothing to do with this allegation of we're going to take collateral that ultimately ended up with no TVs being taken, which were the alleged collateral under the state's theory. The only thing supposedly taken was Mr. Johnson's cell phone, which by Ms. Brown's testimony, they then threw out the window. So no, there is no real collateral here anyway regarding the theft or the robbery.
And is it clear who took the cell phone or
No.
any of the information about the cell phone? Can you give me some clarity on that, on what is actually in the record?
Yes, Your Honor, because even I actually got confused at one point, and I went back and double-checked to make sure that I was stating this accurately. I believe this is accurate for the court. Ms. Brown never said that Mr. Porter took the cell phone. And in fact, Ms. Brown testified, actually even before trial, before her trial testimony, in her pretrial statements to police and at trial, she repeatedly said, I took the phone. I had the phone, I had the phone, I had the phone. She took Mr. Johnson's phone because she wanted to be able to get her clothes back. So she's like, hey, I've got your phone, give me my clothes back, and then, I'll get out of here. She had the phone the whole time. She then at trial, again, not only inconsistent with her pretrial statements, but contradictory to her own trial testimony, she then later says, well, somehow it ended up in the car with us. She then says, a little bit later, that Mr. Orr gave the phone to Mr. Porter, who threw it out the window. So at best, Ms. Brown's testimony regarding Mr. Porter's involvement with the phone was he tossed it out the window over the Chickamauga Dam. Again, that's not sufficiently corroborated, but even if you take that as true, that does nothing to prove his intent with a theft or a robbery. At best, as we discussed in the brief, it's an accomplice after the fact, which he wasn't charged with. So that's it for the phone. And if anything, Ms. Brown is admitting that she was the one who took it all along. And it was from the trial testimony, that portion is in volume 9, I think it's pages like 380 to 384, where she says multiple times that she had the phone. Then it was the trial judge, who I think got this wrong on the facts, at the mid-trial motion for judgment of acquittal said, well, it's either that Ms. Brown had the phone the whole time, or either Mr. Orr or Mr. Porter took it and got it into the car. That is pure speculation. Everything about what Mr. Porter did or didn't do is purely speculative in this case. The trial court saying either Porter or Orr took the phone is not based on any testimony in the record, not even Ms. Brown's. Ms. Brown's testimony was she had the phone and then somehow it ended up in the car. So if we accredit one of her versions, that she left it in the house and somehow it ended up in the car, so someone else had to get it, you then have more contradictions, which is she first said Mr. Porter never got out of the car. He was never in the house. She then says, okay, he was in the house, but his hands were in his pockets. He didn't touch anything. He didn't take anything. So then to extrapolate, as the trial court did, that maybe Mr. Porter took the phone is not based on anything that Ms. Brown said or any other proof in the record. It is pure speculation, and as this court well knows, we cannot speculate people into a lifetime in prison. There's just nothing else there. If the court would like to go back to more of the corroboration.
Let's go back to the corroboration. Your friend on the other side talks about the different types of corroborating evidence, and one of the things that is raised by the state is the text messages that are between Mr. Orr and Mr. Porter. Can you speak to those, please?
Yes, Your Honor, of course. So the first text message that the state points to as corroborative evidence is Mr. Orr's text message to Mr. Porter, should I do her? Now, it's unclear what that means, but even assuming, as the state has posited, that means Mr. Orr was seeking Mr. Porter's approval to kill Ms. Brown as a witness to what had just happened. Nothing about that proves Mr. Porter's intent to engage in any of those crimes for a couple of reasons. Number one, Mr. Porter never responded to that text, at least not in writing. Number two, Ms. Brown, as far as I know, is still alive. And so if Mr. Orr were looking for approval to kill Ms. Brown, that didn't happen, and Mr. Porter certainly did not have some sort of permission to give as the alleged ringleader, as the state has claimed, which is, again, not based on anything in the record. The other text message that the state relies upon is Mr. Porter's text message to Mr. Orr sometime after these events that he was totally violated for real, which was interpreted to mean, I believe he was on either parole or probation at the time, so he was telling his friend, hey, man, what you did got me violated. Now, the state says that the totally violated text somehow shows Mr. Porter's conscious guilt in the crimes that were just committed. So I'll say a couple of things against that. Number one, if someone has just committed a theft, a robbery, and a murder, I would think a parole violation, a probation violation, is the last thing that they would be worried about. So that text proves nothing about his guilt of the crimes that had been committed. And number two, when you read that text in context, the response from Mr. Orr, LOL, I'm taking care of stuff, I got you, is Mr. Orr's acceptance of responsibility, which again, he pled guilty. I mean, he admitted that he's the one who pulled the trigger. Admitted he's the one who did this. And so Mr. Orr is saying, don't worry about it, man. I got you, I got your back. Because you didn't do anything. And so that's it in terms of text messages. The text from Mr. Orr that was not responded to, and the text from Mr. Porter about, hey man, just being here with you when you've just done this, that I had no idea was going to happen, probably puts me at risk of violating my probation or parole. That's it. It does nothing to establish, even if you assume there's corroboration, it does nothing to establish Mr. Porter's intent or shared intent or criminal responsibility for what had just happened. And those are the only text messages the state points to. There were some text messages from Ms. Brown to other people, but not to Mr. Porter. They did not even know each other.
Those text messages, though, did go to Mr. Orr, right? And she was seeking help in a robbery, right? Or a theft, taking back maybe her own property?
One of her text messages to Mr. Orr indicated, like, hey, if you come get me, you can take whatever you want from his house. That went to Mr. Orr. Nothing was taken from the house by her own testimony.
Okay.
But she did send out like a number of other text messages earlier, and that's where I felt like the state's brief was a little confusing, or maybe conflating that, trying to say that those text messages she sent out looking for help, it was implied that some of those maybe went to Mr. Orr, or somehow he was responsible for receiving them or knowing about it, but the record does not support that, does it?
Correct, and that's part of our prosecutorial misconduct argument as well, where the prosecutor references Ms. Brown's text to some unknown third party about sending shooters and being a lot different from what she sent to Mr. Orr. And in closing argument, the prosecutor basically said, she sends a text, send shooters, and then Porter and Orr show up. That is a complete improper conflation of those text messages, who they went to, these unknown third parties that weren't even a part of this case. It has absolutely nothing to do with Mr. Porter's intent, even assuming it's corroboration in some way. I see my time is up. Unless there are further questions, I'll reserve for rebuttal.
Thank you.
Thank you.
General?
May it please the court, Catherine Redding on behalf of the state. The evidence is sufficient to sustain the defendant's convictions. Viewed in the light most favorable to the state, which is a standard of review when we're dealing with a sufficiency issue, there is sufficient evidence for a reasonable jury to find that the state corroborated Ms. Brown's testimony implicating the defendant in the conviction offenses, and that the state showed that he did intend to commit the theft or robbery that underlie the felony murder convictions. And it's important to keep in mind that this case, the defendant was charged with felony murder, and he was charged with the especially aggravated robbery and theft under a theory of criminal responsibility. So that's the background and where we enter, kind of the lens with which we use to look at the proof. And if we look at the corroboration evidence, what we have is Ms. Brown's text history, which shows that she did spend the morning looking for somebody to help her rob the victim. Yes, most of these texts were not to Mr. Orr.
Well, in fact, none of those asking for that kind of help went directly to Mr. Orr, did they?
Oh, Mr. Porter?
Or,
Mr. Porter did not receive any
Okay.
texts.
Right.
Mr. Orr did not receive any of the initial texts. What the record shows is she sent all of these text messages. So we have an idea of what Ms. Brown's
right, I think,
situation
I
was.
get that. We can see
Yes.
from her text messages what she was looking for, but what we're really looking at is what the intent of Mr. Porter and Mr. Orr were.
And I think we have to go further down the phone records and what the texts show. So we have all of these texts from Ms. Brown, and then we have a lengthy phone call between Ms. Brown and Mr. Orr.
But we don't know what that phone call was
We
about.
do not, but we do have a text message that follows that conversation that says, when Mr. Orr announces that they are 15 minutes out, she says, okay, when you get here, the TV's to the left. That text message doesn't make any sense unless a reasonable jury could infer from those text messages that the phone conversations, which obviously were not recorded, we don't know what they say, but that there was a discussion of the robbery, because otherwise you have a text message from Ms. Brown to Mr. Orr talking about the location of a television out of nowhere. So a jury, viewed in the light most favorable to state, a jury could reasonably conclude from that text message and from what we know of Ms. Brown's morning and what she was planning, that the conversations that she had with these other people were repeated in some fashion to Mr. Orr, such that texting him, here's the location of a television, here's a photo of the television, would make sense to Mr. Orr. And if we go back to kind of the earlier conversations, what we have is Mr. Orr's phone records, going back to the corroboration, Mr. Orr's phone records showing that immediately after he gets off the phone with Ms. Brown, he calls the defendant. And in fact, he calls him twice. Then we have Ms. Brown texting Mr. Orr to ask how long it's going to take him to get there. We have the phone records before Mr. Orr actually calls Ms. Brown back. He talks to the defendant 4 more times.
But again, we don't know what those phone conversations were.
We don't. But viewed in the light most favorable to the state, it is reasonable, a reasonable jury could conclude that there were conversations between Mr. Orr and the defendant. And given the conversations that we have with the text message about where the location of the television and the photograph of the television, a reasonable jury viewing this evidence in the light most favorable to the state could conclude that there was more than just a conversation about, hey, what time are you going to get me? Can you give me a ride? My recollection of the record is that they showed up in Mr. Orr's vehicle, or I believe his mother's vehicle. So it wasn't a matter of, Mr. Porter, can you give me a ride? Mr. Porter, can you help me? There was more to that. And it's important. Again, viewed in the light most favorable to the state, a reasonable jury could conclude that there was an agreement.
Well, they would conclude that this conversation happened between Mr. Orr, but they would also have to infer that Mr. Porter was privy to that conversation and knew the contents of what they were talking about.
Yes, they would. And so I think, kind of broad picture, knowing what Ms. Brown had in mind that morning, knowing that she contacted Mr. Orr.
But is that not just too big of a leap to go from what we know she was, I think that's the clearest thing we have in the record, is what she was looking for help with.
Yes.
But then to say that without any direct evidence in the record that she, or really much circumstantial evidence other than speculative, that she communicated that to Mr. Orr, who communicated that to Mr. Porter, who agreed to go along with it. I mean, I'm just struggling with the actual evidence in the record, and I know you've got what you've got in the record, but
I'm not sure I'm articulating this very clearly, but I think kind of back to your point, Judge Cranolds, the first issue is whether a reasonable jury could conclude that Ms. Brown's testimony was corroborated. And so then do we get to the point where we have Ms. Brown's testimony and then we have the additional testimony? And it's the state's position that we can corroborate her testimony because all that's required is just slight corroboration. And you don't have to corroborate every single thing that she says. And the text messages, the phone records, the cell location data all track what she is saying, and that it's establishing what her mindset was in the morning. She was looking for help. It's showing Mr. Orr had a phone conversation with her. It's showing all of these very extensive communications between Mr. Orr and Mr. Porter. It's showing the two of them getting in the vehicle and going to Ms. Brown's location.
General, where does Mr. Orr get the weapon from? What does the record say?
According to Ms. Brown's testimony, which of course has to be accredited, right, and we can infer that it was given the verdict, her testimony was that at the end, when they got back to Chattanooga, Mr. Orr handed Mr. Porter the weapon and said, here's your gun back.
As if to return the weapon that he had received from Mr. Porter?
Yes.
Okay. So if we're drawing those inferences in favor of the jury's verdict here, your friend on the other side, I think this is fair to say, relies heavily on the jury's acquittal of Mr. Porter being a felon in possession of a weapon.
Yes.
Is the state's response that's just an inconsistent verdict under Davis and that's what we have, or is there more to it?
I don't know that it's an inconsistent verdict, but I do think that it had its effect on the evidence underlying the convictions for counts 1 through 4 is limited. In count 5 is his possession of the weapon. And all there is Ms. Brown's testimony. There's nothing else. So it was appropriate. Okay. But here, when we're talking about felony murder and we're talking about criminal responsibility, we have more. We don't have just Ms. Brown's testimony because we have the text messages, we have the cell phone location data, we have the conversation between Mr. Orr and the defendant, and it's the state's position that viewed in the light most favorable to the state, a reasonable jury could infer or could construe the defendant's text message about totally violated to mean that the defendant was viewed in the light most favorable to the state. It's not about his probation or his parole being violated. It's about, it's an acknowledgement of his role or his participation in these offenses. And as to the text where Mr. Orr asked if he should kill Miss Brown, the fact that the defendant didn't respond is, frankly,
Well, he didn't say, should I kill her? He says, should I do her?
Well, viewed in the light most favorable to the state, a reasonable jury could infer that when he said do her, he meant kill her, given that it was sent just after the text message, as it wasn't like Mr. Orr later when he was at the hotel with Miss Brown said, should I do her? He was asking this in the immediate aftermath of a murder. He's asking Mr. Porter, should I do her? A reasonable jury viewing this in the light most favorable to the state could conclude that he meant, should I kill Miss Brown? And the fact that he is asking Mr. Porter doesn't necessarily, I tend to say, that doesn't necessarily mean that the state is arguing that Mr. Porter is the ringleader. But it means that Mr. Porter is not just a bystander. He's not along for the ride. He is criminally responsible for this, and that is.
So let me push back on that gently. Let's assume the jury does not credit Ms. Brown with respect to the felon in possession count. As you said, it's possible the jury didn't credit her in that regard. If Mr. Porter did not provide the weapon to Mr. Orr, how is he criminally responsible for anything? I hear your friend on the other side say all you have at that point then is presence. You don't have encouragement, you don't have evidence of Mr. Porter taking anything, actually participating in a theft. If he is not providing the weapon to Mr. Orr, where is his responsibility at all then?
I'd first like to clarify, the jury did not acquit Mr. Porter of the possession. That was the trial court dismissed.
Trial court, yeah, yes, okay.
So the jury,
fair enough.
We don't know what the jury thought about that.
Fair enough, but let's assume that
Sure.
the facts are, just for sake of the hypothetical, that Mr. Porter did not provide the weapon to Mr. Orr. Where is his responsibility then for theft, for felony murder? Where is his responsibility then?
Well, this case is based on circumstantial evidence.
It is, and that's what I'm trying to get to.
Sure.
It seems to me the weapon is really important.
I think
it's really important, and so if we remove that critical fact, what else do we have that would support the convictions?
I would agree that the weapon is important, but I don't think that it's the end of the story. I think that Ms. Brown's testimony, she acknowledged at trial that she's not sure how the defendant got into the residence. But she said when she went into the residence that she walked in and she saw the victim's body in front of her. She saw Mr. Orr to the left, and then she saw the defendant to the right. She said that his hands were in his pocket. She said she didn't see him take anything. That does not mean that she wasn't there when the shooting happened.
True, but there's no proof that he took anything, right? Is there any proof that Mr. Porter took anything?
There is proof that items were taken, the phone was taken from the residence, but no, there's no proof that the defendant is the one who took it rather than Mr. Orr, but again, criminal responsibility.
Is there any evidence that anything other than the cell phone was taken? The cell phone is fine. I mean, I understand the theory on that, and that would be perfectly sufficient perhaps. Is there any other item that is taken from the victim other than the cell phone?
My recollection is that the state did argue at trial that cash and pills were taken. Mr. Johnson was providing Ms. Brown with Roxy's to sell, and it was Ms. Brown's testimony, and that's backed up by text messages, and it was Ms. Brown's testimony that she had acquired about $500, and the testimony from the state's witnesses is that no cash and no pills were found at the residence, even though we have testimony from Ms. Brown that there should have been cash and there should have been pills. So we have that, but we also have a statement from the defendant that Ms. Brown testified to at trial. She said that when she went into the residence, the defendant was standing by the dresser. The dresser drawers were out. It looked like the house had been tossed. And that the defendant told her that she knew there was something of value in the house, she better start searching. So I think that given circumstantial evidence, but given if we accredit Ms. Brown's testimony, we find that it was sufficiently corroborated as the jury did. We conclude from the number of phone calls between Mr. Orr and Mr. Porter. We can conclude from even without the gun, from Mr. Porter's own statement and from Mr. Porter's presence in the house, that in the immediate aftermath of the victim being beaten and shot in the chest, that the defendant was criminally responsible, that he was more than just merely present. And I think he also...
So what I'm hearing, though, is that he communicated with Mr. Porter. We don't know the substance of it, but maybe we can make some inferences that Mr. Porter is going to do something. We have his presence at the house. What are the statements that Mr. Porter is making at the house that would show that he's either facilitating or actively engaged in or benefiting from or helping to further the theft? What are those statements?
Ms. Brown testified that when she went into the residence, the defendant said if she knew there was something of value in the house, she better start searching.
Okay.
So given that, and also I'd point this court to the Eric Boyd case, which was criminal responsibility.
Sure.
I don't think that it rises quite to the level there, but in that case, this court discussed presence and companionship of an accused before and after an offense being circumstances from which participation in a crime can be inferred.
Not alone sufficient.
Correct.
Right? But what I'm hearing you say is that it's not alone, that we have the statements of the defendant and text messages, phone calls between Mr. Porter and Mr. Orr.
And if we look at Mr. Porter's actions after the shooting, I mean, we have the text message, totally violated, and a reasonable jury could construe that to be a statement about conceding to his role. And then we also have the fact that Mr. Orr stopped the vehicle multiple times on the way back to Chattanooga. The defendant never got out of the car, never said anything, never tried to part ways with Mr. Orr. The phone records show Mr. Porter was sitting in the car watching YouTube on the way back to Chattanooga. I mean, these are not... We have companionship, we have presence, we have statements, we have enough evidence from which, when viewed in the light most favorable to the state, a reasonable jury could infer that there was more to this arrangement, especially leaving Chattanooga. There was more to it than just simply do you want to come along for a ride? I mean, I believe it's 11 phone calls in the course of an hour, and it's every time Mr. Brown and Ms. Orr speak, immediately the defendant gets a call. Multiple calls, and just follow up. And so if you look at all of it together, under the standard of review that the state as the prevailing party is entitled to for reviews of sufficiency on appeal, a reasonable jury could find that the defendant was guilty of the conviction offenses. Unless this court has any further questions, the state asks this court to affirm the judgments of the trial court. Thank you.
Thank you.
A few points on rebuttal, Your Honors. First, just factually, the quote from Ms. Brown was, he said, if I knew there was anything here for real, for sure, I'd be searching. That is entirely unclear as to whether that meant Ms. Brown should be searching, Mr. Porter would be searching. What is clear is that no one was searching. I would be searching was the testimony, not, you should be searching or you are searching. And that's in volume 9, 384 to 386, and it's quoted in our brief regarding what Ms. Brown said about when Mr. Porter was supposedly inside the house. But I want to go back to the legal standard more importantly. The state does not get to use the light most favorable to the state or reasonable inferences made by the jury unless they first clear the corroboration hurdle. Corroboration is not a jury question. It was for the trial court to decide first. And that is where the error is. So a few things on the corroboration rule. It is not slight corroboration. We have that standard in other corroboration rules in the law, not the accomplice corroboration rule. The accomplice corroboration rule requires that independent of the accomplice's testimony, there must be proof that fairly and legitimately tends to connect the defendant with the commission of the charged offense. That is more than slight corroboration of Ms. Brown's testimony. And there's a reason why we require that. She changed her story multiple times before and during trial. We do not, this court and the parties on appeal, we do not have to accredit her testimony with regard to the corroboration requirement. I think the state does get that more favorable standard if it goes to the jury. But if this court concludes that there was not sufficient corroboration, we're not taking things in a light most favorable to the verdict at that point. We're looking at this under the corroboration standard. Regarding what the state had for corroboration, there was nothing, no more evidence, no more alleged corroboration of the theft, the robbery, the murder, than there was of the possession of the firearm. And I appreciate my friend bringing up the fact that that never went to the jury. The trial court did find no corroboration of Ms. Brown's claims about that gun. The claims by Ms. Brown about the cell phone being tossed out the window, there's no more corroboration of that, or the state has not put forth any more corroboration of that than they did of the gun. It's almost the same testimony from Ms. Brown. Mr. Porter disposed of that item. He disposed of the gun. He disposed of the phone. If there's not corroboration regarding the gun, there cannot be corroboration regarding the phone, period. And we're not talking about inconsistent verdicts because we are talking about the trial court's decision on the corroboration legal standard before this goes to the jury, before we look at things in a light most favorable to the state, before we accredit Ms. Brown's testimony. And that's exactly why the accomplice corroboration rule still applies in this case. Unless there are further questions, I will just sum up by saying, as this court has pointed out, there's plenty of evidence about Ms. Brown's intent. There's plenty about Mr. Orr's intent. The state has nothing about Mr. Porter's intent, and nothing that it has put forth, corroborative or aside from the corroboration, independently regarding Mr. Porter's intent. Nothing is sufficient to uphold these convictions. We're asking this court to reverse and enter judgments of acquittal, or for the alternative reasons in our brief to remand for a new trial because of the hearsay and prosecutorial misconduct during closing. Thank you, Your Honors.
Thank you. Thank you again to both the attorneys for your good arguments and briefs, and just appreciate y'all making the effort to be here in Chattanooga, a little different venue. We're all out of our usual environment, so thank you all for making the effort and being here for the students. So we're going to be in recess, and again, the students will have the opportunity to ask questions of the lawyers, and then we're going to take a lunch break, and we'll be back for our last session at 1 o'clock.
Yeah, I think that's right. As students that are here, take advantage of this opportunity. This is not something you would have an opportunity to do if you attended court. So if you were otherwise hearing this case in Knoxville, which is where we'd be hearing it otherwise, you wouldn't have the opportunity to ask the lawyers questions either about the case, about what they do for a living, about how they got to law school, why they're interested, why they do this work in particular. These are outstanding advocates. Take advantage of that opportunity as we go. So, yeah, thank you all.
All rise.